Justice Kollapen, but let me greet you formally. Good morning.
Good morning, Chief Justice and members of the Commission, and thank you for the invitation.
I know you're a brave man, but that seat is not always easy to handle. Should we start slow? Are you ready for very serious questions?
I suppose as ready as one can be under the circumstances, Chief Justice, but
All
yes,
right.
yes,
Okay.
yes,
Okay. You were with the Lawyers for Human Rights was it for 4 years or more?
It would have been approximately 4 years, from about 92 to 96 years.
Did you start as national director or did you start lower than that?
I started lower than that. I headed up the penal reform project that looked at really the rights of prisoners. I then worked on a program called the Political Prisoner Release Program. That was as a result of the negotiations between the National Party government and the ANC that required a mechanism to facilitate the release of political prisoners. I then became the National Projects Director in the organization that had responsibility for the various projects that the organization ran, including rights of people with disabilities, children's rights, women's rights, and then after that became the National Director.
Did you take over from Mr. Brian Curran or someone else?
I took over from Mr. Curran, yes.
Yes. And when you left, you then went to the South African Human Rights Commission.
That is correct as well.
By the way, who did you serve under? Who
I
was the chair at the time when you joined that body?
The chair was Professor Bani Pityana.
Yes.
I served under him, and then when he went on to take up a position at UNISA,
Yes.
I served under Mrs. Shirley Mabusela for about a year.
Yes.
She then became the chair,
Yes.
and I served as vice chair
Yes.
at that time, yes.
Well, still on this lighter note, you were quite visible, and you struck me as someone who didn't quite like being dressed formally, even as chair. Was it because that's in the nature of that commission, or was it the activist in you who couldn't allow himself to be contained by ties and suits?
Chief Justice, maybe a bit of both, but there were occasions when it was necessary to be dressed formally, and I would do so. But in an ordinary working day, one would have a jacket at least and a shirt, and one's tie close by.
Well, but your tie wasn't properly done. I mean, you could see a lot of reluctance in that tie.
Chief Justice, maybe that's why my surname is Kollapen and not Typen.
What is the meaning of Kollapen?
I'm told that it's someone who's part of the community of a temple child, put it that way, in South India. So people who are very much associated with the culture and religion and language of the South Indian people. That's my origins, South Indian, yes.
All right, okay. And for how many years were you chair of the South African Human Rights Commission?
I was chair for 7 years, from 2002 until 2009, and then my term of office ended.
What is it about your role there that you particularly pride yourself about?
Well, I think the work of the Commission at that time, in particular around the areas of equality and non-discrimination, was important in sending out a message to South Africans that the Constitution was meant to be inclusive. And therefore, despite one's own personal predictions, it had to make space for everybody, and even recognizing the right to be different. And that wasn't easy, because we were a society that largely developed separately, that was suspicious of each other. We wanted equality for everybody who was like us. But if someone was different from us, then we didn't. So I think the public education work in the Commission was something that I thought was important at the time. And in part, the Commission had to have this public profile. It's not as if it sought the publicity, but it had to have this public profile in order to communicate its message to the public. I also think the Commission's work around social and economic rights was important. In particular, its engagement with government, how government gave effect to its mandate to realize social and economic rights progressively and within its resources. It wasn't always easy, but I think that began to consolidate the idea that this idea of human rights can be translated into meaningful difference in the lives of people.
Well, a question that I may probably only ask you, and not necessarily others, is this, and that has to do with your role in that line. Considering where we come from as a nation, would you say equality, human rights has been given practical expression, or is it more to be found on paper and at a theoretical level? And it's a very deliberate question. I'm looking at areas of economic empowerment, employment equity, and any other area you can think of, even in terms of who lives where.
Chief Justice, I think we've probably moved beyond the paper promise, and that there have been attempts, laudable, to advance the promise of the Constitution and to convert it into reality. And if one looks at, for example, programs that looked at housing, education, we have a considerably wide reach in terms of education. It's close to 100% in terms of the number of children who can attend school. There are questions, obviously, about the quality of education. So, yes, we have made progress. But in other respects, if one just drove home from my house to this meeting today, you see young families pushing along these trolleys where they collect plastic for recycling. And they work a full day and they earn 150 rand. It's a mother, a father, and a child in the hot sun. And certainly for them, the idea of equality is yet to arrive. So if you look at the land question, I sat in the land claims court for 3 months last year. If you look at the state of the economy in many other areas, and the National Planning Commission prepared a diagnostic overview of, and it highlighted a few issues that South Africa is still largely a divided country. And in a sense, that's the challenge that faces all of us, including judges, to locate our work within an understanding of that context.
And I haven't picked up much enthusiasm to confront issues that relate to economic empowerment, especially entry into the mainstream economy. I've raised it several times, and there would be a sidekick from time to time to say, you know, this guy focuses on these economic issues. None of his business. It's almost as if we're discouraged from saying, but we are about justice, and it doesn't look like there's any justice when it comes to where it pains the most. Issues of the stomach, meaningful participation in the economy. Given your background, why is it that it's almost as if we're being encouraged to be comfortable with whatever employment government can give you and the little crumbs that are there, but confronting the paucity of participation by the previously disadvantaged in the economy, something that you can be attacked for, something that you can be mocked for, something that you can attract all manner of writings about you for, even if they may not be direct. Why is that so?
Well, Chief Justice, I'm not sure how qualified am I to comment on it, but let me try.
I'm just trying from your background as an activist in
Sure.
the area of human rights, equality in every respect.
The Constitution contains the imperative, a compelling one, that South Africa belongs to all who live in it. And as you point out, the reality is that in terms of its resources, we haven't got there. And perhaps if one went back to the early 90s, maybe the problem could be identified there, that we dealt with what was required in terms of the political transformation of society. But we didn't change much else. And there were two prongs, in a sense, to the transition, as I see it. The one was reconciliation, and the other was transformation. Now, it seemed we focused quite substantially on reconciliation, important as it was then and important as it still is now. But I have a sense that we focused less on transformation, without recognizing that reconciliation in the true sense would not be possible without transformation. You couldn't do the one without the other.
Yes. Just as an aside, doesn't it look like we follow narratives? Some smart people out there have realized that people have outsourced their thinking responsibilities. In fact, an empirical study has been performed. Only 87% of the people just consume whatever narrative, whatever information comes their way, and that's been thoroughly exploited by those who have seen through all of us around the world. So people decide what you're going to talk about, what you're going to think, and none of them is going to be what matters the most. None of them is going to be the economy, none of them is going to be the land, none of them is going to be spatial development, nothing. You must talk about government performance and whatever else. Isn't that the problem? That instead of being as creative as we were before '94 as South Africans across the Calabar, we have become victims of the narratives. We just follow what others dictate we should follow. If you try to veer off, there's a ready attack from all sorts of angles, and then we have learned to behave ourselves. Isn't that the reason why your human rights agenda as an activist has not become what it ought to have become, partly?
Well, that observation may well be correct in the sense of how the societal discourse is constructed and who constructs it. But at the same time, we as South Africans must accept the responsibility then for the reconstruction of that discourse, not so. Because we owe it to ourselves and we owe it to the generations that follow. If we are asked in 20 years' time, why did you allow that absurd construction of the discourse to happen? So, for example, today, people say it was unimaginable to have had a system like apartheid. People say we can't believe that such a system was allowed to continue for so long. Now, in 30 years' time, if I'm still living, and if someone asks me, how is it that this generation that lived during this time allowed the gross inequalities in our society to happen? It's the same question. It deals with different subject matters, but it raises the same question. And I think we must accept that responsibility. How we discharge it in the various work we do is a different matter. But that consciousness, we must never lose sight of that, because wherever I go, I'm starkly reminded of people who live outside the Constitution. And I mentioned this previously. I'd gone to a village called Khapasha in Skukuni many years ago, and had spoken about human rights, and I spoke with respect, perhaps passionately about it. And an old man then got up and responded, and he said, I enjoyed listening to what you had to say, but if you don't find this disrespectful, it's clear to me that this thing that you call human rights has worked for you. I can see the way you dressed, I can see the car that you came, and I promise you, one day when it works for me, I'll be even more passionate than you are. And I thought that was a fair observation.
Well, before I stepped out of your previous life in an attempt to ease you up, here is the point. I was asked to come and launch the Kim 4 corporate governance report. And I went ready with information which was in the public domain about the open disregard for the Employment Equity Act, where white males in their majorities are right at the top, sprinkle some white woman here and there. But more importantly, you can be equally qualified as a black man as your white compatriot, if not more, and even have more experience. From newspaper reports, at least two, the difference in salary was 30,000. Two, a white woman would definitely earn less than a white man. Three, a black man would earn less than a white woman. Four, a black woman would certainly earn less than a black man. So I confronted them with these figures and they were very uncomfortable. Isn't our problem that we want people to be comfortable even about wrongdoing? We suffer from approval addiction. We want people to like us and to write well about us, the same way the apartheid system would say, "Huyeman," referring to a puppet. And that is why nothing is changing, because there's an agenda that we have allowed ourselves to fit into. And there is an agenda that doesn't want change. And if you go into the Constitutional Court as a judge that doesn't appreciate this, you'll always be trying to court favorable comments, so that nobody ever has reason to say, but there was criticism of your judgment here and there. You don't want to be criticized. You want to look like you are a superstar that you are not. Isn't that the problem? Generally in society, that fits into the mindset of judges.
Well, I think that may link to your earlier comment about how we construct the discourse. And once a discourse is constructed, then there's this desire to seek to want to fit into that. But you've raised a very formidable issue, Chief Justice, and one that I have no doubt judges must be alive to every day, because when one does one's work as a judge, you are required to adjudicate. You're required to bring a sense of justice to what you do. But you can't do that without a full appreciation of the context. And with respect, having been a judge for many years now, I'm not satisfied that amongst judges we have that discussion sufficiently. We talk about the cases we must adjudicate, but we don't talk about why is it that you come to work every day? Why is it that you've put up your hand to become appointed as a judge in the High Court? What is it simply your judicial skills that you bring, or is it a bigger vision of what you want to see this society move to, and how in your small way you can make that contribution? And I think to some extent we are guilty as judges that we don't have that discussion amongst ourselves.
You use the word, which I think is critical, consciousness. The problem is, before you even talk to other people, what is your mindset? With which consciousness do you approach the issues? As somebody said, I don't understand how the Constitution is crafted the way it is, and there's no reference to apartheid at all. Did we want people to forget that it ever existed? What is this? You can't even criticize it easily anymore. It's like it never existed. It has no impact. Isn't that part of the problem?
Well, that may be, and just not the Constitution, the legislation that established the Truth and Reconciliation Commission that was meant to deal with apartheid doesn't have the phrase apartheid. Now, I have a granddaughter who's 7 years old, and I wonder when she's older, and she asks me about apartheid, and I say, well, this is the birth certificate of the nation. And she might say, Tata, but why is this word apartheid not there, but the conflicts of the past, as if there were two groups of people equally positioned who were having a fight with each other?
We don't deliberately and quite intentionally touch on the fundamentals that we ought to grapple with to really change South Africa in the right direction, do we?
No, I don't think we do, and I think maybe in part we got carried away with this idea of this limited understanding of reconciliation. You will recall that in the early 90s, there was a big fear from the international community as well. What would happen to the minorities in this country? And that fear almost drove a lot of the processes that we had to put in place, mechanisms to ensure that the interests of other groups were protected against the majority. And it's kind of that sensitivity that continues to play itself out, almost at the subconscious level. So the debate around land, for example, you would find that subconscious kicking in of, well, what about people who feel vulnerable? Well, the majority are vulnerable.
Well, I think sensitivity for the interest of the minorities is good. I don't think we should ever live as if they don't exist. But I think becoming a victim of narratives and a toy of what others want you to become is a wrong thing. Anyway, I'm sure you are relaxed now, Justice Kollapen.
You got me all excited, Chief
No,
Justice.
that was the whole idea. I was playing in your area of expertise so that you can be comfortable and then we can ask you questions. Why do you think? My own understanding is that you've been a judge, full-time judge, for less than 7 years. Am I right?
I was appointed full-time in mid-2011, so I think...
Yes,
that-
May
yeah,
2011.
yeah, so that would probably take me to 8 years, 9 years this year.
Is it? Hey,
Yeah.
forgive my numbers, man.
Yes.
2011. I was counting with my fingers at 12, 13, 14, 15, 16, 17, 18, because we are not yet at May 2090. So it's 7 years
Okay.
and some months. Yes, so my fingers did not lie. Now, why should you as a judge, apart from your long experience in the human rights sector, which is related to constitutionalism really, why should you be the one? Just in your own words, tell us now and brag as much as you can. I know you have the capacity to do so. Just brag and tell us why you are the right person for one of these positions.
Thank you, Chief Justice. I think that if I look back at my career, then I've been pretty fortunate to have had quite a wide and diverse exposure to different areas of the law and in different formulations, from being an attorney in private practice, to working in an NGO called Lawyers for Human Rights, to working in a state institution such as the Human Rights Commission, and then working as a judge, all of which happened within the same setting of my consciousness, but required different skills of me. So I think in that time, I got a fairly good sense of, one, the power, limited as it is, of the law to change society and to transform the lives of people, and my own ability to use my legal and other skills to that end. So I think as a judge in the last few years, I have internalized that, and with respect, it may emerge from my judgments. I also chair the Law Reform Commission, and that's also given me an opportunity to look at issues of law reform outside of the court system, looking at law in society and how law can be an agent for change and how the law reform process is just as important. And so all of that culminated in a acting stint of 6 months in the Constitutional Court in 2017, which I enjoy thoroughly. It also enabled me to firsthand see the functioning of the court, the ability to work with other colleagues to the highest and most exacting standards, the ability to allow yourself to be persuaded, but also to have the opportunity to persuade, the humility sometimes to accept that an initial position you took may not be right, but at the same time, the courage and the fortitude to be able to say, I disagree with that position, and I will write a dissent. And that happened in that time within an environment that I found was rewarding, very fulfilling, wonderful collegiality. And if I may say, the green robes look much better on me than the black robes. But that's another matter.
Let me, let me ask you, you know, we've been flowing, I'm sure no question can shake you now. Let me ask you this question. Do you think judges are capturable, and if so, how? How can it happen? In other words, do you think judges are insulated from what has become known as capture in South Africa, or could they as well be victims of capture? And if you think they can, which avenues could be exploited to get to them?
Well, in response to the first question, I must say that yes, I think judges can be the subject of capture. Because to suggest that judges are not capturable, would suggest somehow that judges have some kind of superhuman type of qualities that immune them. We live in the same society. We are the subject of the same influences that may be brought to bear on others who have been captured. So it's how one lives and acts with integrity that's important. And I don't think you need a rule book to tell you about integrity. It must be part of your moral DNA, of your moral compass. The rule book might give you the nuances, but instinctively, each of us sitting here knows exactly when something is right and when something is wrong. The second part of it is to be alive to those influences that can capture you. And sometimes it's innocuous things. It's a threat to your own wonderful middle-class existence, for example, that might push you in a particular direction, that might render you more likely to want to protect middle-class interests. That's not capture in the obscene sense, but it's a dereliction of your own duty, not so. Because then you're protecting your interest and the interest of those who are similarly situated to you. So you have to be sensitive about that all the time.
I would want to know more about how it can work. I'll give you examples of how it can work. And I hope I won't be misunderstood, because quite often I'm misunderstood, and sometimes I think it deliberately. At some stage, somebody distributed shares running into millions. I remember at least one judge was a beneficiary of those free shares. He didn't have to pay anything. Now, it may not have been the plan to capture, but it has the potential to capture you. Because the next time you have some case, now you've given me shares worth 6 million rands for free, the likelihood that I'll remember looms large. That's the first thing. Two, at some stage there was this tendency to brand some judges as highly or well respected and progressive, and brand others conservative. And together with that was a pattern, I'm not too sure it has disappeared, of always praising certain judges even if they have done nothing of consequence. Almost have to send them, as if to send a message to the rest of the judges. These should be your role models. Do what they do. And two, even if a judge can be terribly wrong, terribly, there will always be praise coming from a certain quarter over that judge, that judge can never do anything wrong. Now that seems to be an avenue for capture, because then a message is being sent loud and clear. You've got to do what so and so and so and so are always doing. And in case they never decide against certain interests or groupings, then that's the way to go. You will earn yourself points if you always align yourself with them. I think that's another possibility of well-calculated capture. Or it may not be intended, but the possibility looms large as well. What other possibilities are there?
Well, that certainly is something that I think happens in our society, and one need to do no more than read the media and read what commentators have to say. And I agree with you, it would be seductively simple to fall into that trap, to be regarded as a judge who's regarded highly. But that can't be the test of what you must do. You must apply your mind with integrity and diligently to your work. And if you're going to write a judgment that is true to your own view with regard to the case, then that is what you must do. But again, this is about how the discourse is constructed. So the problem is not the labels that become attached. That is part of the bigger discourse with regard to how we transform or don't transform society.
Whether there is corruption only in government or there is corruption everywhere, even in the private sector. It's how the discourse is constructed.
Precisely. I mean, the Constitution provides that the Bill of Rights can apply horizontally and vertically. But there's hardly much work done on the horizontal application. So 54 of the largest economies in the world are not governments. They are private companies. So some of those companies have economies larger than some states. Those states are subjected to the most exacting requirements set by the United Nations. But those companies are not. And companies impact on people's lives every day. So, so there's a disjuncture, and I'm not saying the private sector is under the same responsibility as the state in discharging human rights, but they have the potential to impact considerably on human rights and on transformation and on development. But the focus on them is considerably less because of this disjuncture. So when I was at the Human Rights Commission, someone said, well, look, how do you assess whether the commission is actually doing its work? And I said, well, someone said, well, let's see how critical you are of government. And I said, well, if you're going to use that test, we'll pass the test every day. Because before tea time, we could find 6 things wrong. That can't be the test. That's too simple. It must be more nuanced than that. And if the Constitution is about accountability for the exercise of power, then we must recognize that private actors exercise considerable power in this country and elsewhere. And therefore, the debate around accountability of private actors is an important one. I worked with Professor John Brugge on trying to develop some UN norms for accountability of private actors. But the kind of appetite at international level was that it would be soft, do no wrong, but not the kind of hard accountability that we see. Yeah.
Well, you get funding even for it, Anyway, Commissioner Mpofu.
Thank you, Chief Justice. Good afternoon, Justice Kollapen. Yes, no, I just wanted to follow up on one issue that the Chief Justice has raised about judicial capture. There is a concern which, fortunately, the Chief Justice raised in one of his speeches, particularly about judges, not individual judges, which I think is more serious, the judicial capture in a more general sense, that the judiciary might be tempted once again to follow narratives. For example, there's the current narrative of the new dawn and all sorts of things like that, which some people call the false dawn, yeah. But it's a very serious issue which the Chief Justice raised very sharply, that judges should resist following, the popular narrative on social media or whatever about what the reality is on the ground. And that, I do a lot of these political kind of cases. And I can assure you that there was a certain discernible change of mood in the judiciary in general, in embracing the so-called new dawn almost with the same vigor as rejecting the old dawn or the one of the Zuma era, whatever it was called, sunset, I don't know. But the issue is that, to what extent is that, I think you called it, you used a very nice term, the not obscene, in the not obscene sense. I mean, we're not talking about a judge taking a brown envelope, that's just criminality, yeah. I'm talking about probably a subconscious buying into a particular narrative, whether it's around the issues of land, whether it's around the broader issues of not wanting to find against or to rock the boat against reconciliation or whatever the popular narrative of that time is. Yeah. How can we, or can we, insulate society against that?
You mean, can we insulate the judiciary against that?
Well, no, society, the judiciary
Okay.
is just, yeah.
Well, I think in part, the Constitution and its vision must serve as the framework then for whatever you do. So if it's a land issue, for example, whatever the popular discourse is, the understanding must be that there's been a deep and unimaginable historical injustice on the question of land. The Constitution requires that to be dealt with, and for that historical wrong to be converted into a historical right. And that must be the trajectory that you must take as a judge. Whatever the other distractions may be, if you act with integrity and if you are true to that, then I think, and I'm not saying it's an easy task, because we are all subject to influence, either directly or indirectly. There's something that might rest in your subconscious, then can deal with that. And to that extent, I wonder whether judges become sufficiently engaged with the society around them. And there's been a debate that judges should be a bit removed. But I'm not sure if I necessarily agree with that. I think if you've been inside a prison or inside a shelter for women, or taken the night train from Lindela to Resanagasio, you would understand what happens there, and that helps you a lot as well. So I'm an advocate for saying that judges should be more engaged in the societies in which they live. And I'm fortunate I live amongst the same people I was born with. And they ground me all the time, because they're not afraid to tell you about what you do and what you should be doing in your work. But I'm afraid I don't think one can create a situation of insulation that works 100%. There'll always be that risk. But I think one way of dealing with this as well is that judges need to talk more amongst each other, and I don't think that happens. They talk about their work, they don't talk about the context within which they do their work.
Thank you. Just as a follow-up, yeah. I think the other side of the coin, of course, becomes the issue of the praise that one gets. For example, the pendulum can swing in the other direction, so that if you are always fighting against the government, for example, then you are praised as independent. And some people might be tempted to do that, which is as wrong as being captured by the popular narrative, because it doesn't follow that the government of the day is always wrong. Are those not some of the dangers, the undue praise and the mischaracterization of maybe fighting against the government as independence? Those are not the things that really might influence, because we're all human, as you say. So you might be flattered by that kind of praise. Yeah.
No, those are real risks, but I also think that depending upon how vain or how insecure one is, you will want to hanker for that praise as validation. But that's not the validation you must seek. I remember my old boss, Professor Bani Pityana, said, because there's no such a thing as absolute independence. He says you can be so independent that you live in splendid isolation. But who wants to live in splendid isolation? So one is independent, but that independence is a kind of real independence that operates in the context within which you work. Yeah.
Thanks, Susha.
Thank you so much, Advocate Mpofu SC. J. Pilia?
Thank you, Chief Justice. Good day, Judge Kollapen. I want to refer you to the case of State versus Maluka, which you have referred to on page 12. I just want to find out whether at the time when you handed down this judgment, were you aware of the Constitutional Court decision of divorce, which dealt with the same issue? Is a case where it deals with Section 77(6) of the Criminal Procedure Act, where you gave a directive to all the magistrates that any matter wherein an accused has to be committed in terms of Section 77(6), then that matter should be sent automatically for review. And you even stated that it will be referred to the Department of, or to the legislature for it to consider passing legislation in that regard. Were you aware at that time that this matter was extensively dealt with by the Constitutional Court in the matter of divorce, and also that in this section, the provision was that once the magistrate or the presiding officer is of the opinion, or after having considered the evidence, that the accused person had a mental, or had to be referred for mental, to be declared as a mentally challenged person, then you had to commit. In other words, without further, you must commit that person to a mental institution. Now, divorce dealt with that issue, and it was revisited, and I should think there was also a recommendation that the legislature should deal with that issue further.
Thank you, Judge Liu. I don't have the judgment with me, but if I can't recall, my recollection doesn't take me to divorce, and if there was such a thing, then certainly, if it wasn't dealt with in the judgment, then that would have been an oversight, but I can't recall exactly.
Yes, why I'm referring you to this judgment is because after this judgment, there were many matters referred coming for review, coming from the Magistrates Court to the High Court. And I wrote a judgment with regard to that, wherein they were referring to your judgment that these matters are brought on review based on your decision, and it would seem the magistrates, or the case of divorce was not brought to the attention of the magistrates. So in the Northwest, it doesn't apply. I don't know whether in Gauteng or other divisions it applies.
I think the idea was to ensure that I suppose the principle of the judgment was that the consequence of involuntary incarceration could be far-reaching for someone with a mental health problem, and therefore you needed some kind of check and balance to ensure that that decision was properly taken and taken with integrity. But I take your point. Thank you.
Minister?
Thank you, Chief Justice, and good afternoon, Justice Kollapen.
Afternoon, Minister.
Let me outright declare that you were my boss until when we both left the NGO world to join the state in different arms of the state. There was a matter that arose in the discourse yesterday around access to justice from the high cost of litigation point of view. Now, you alluded to your currently presiding over the Law Reform Commission. and maybe you'll want to elaborate further on how long and what kind of work gets to be done there. But one of the projects relates to this very same issue. And I wonder if you want to share with this commission as to what the Law Reform Commission is doing about it, and where it derives its mandate from in addressing the issue. Thank you.
Thank you, Minister. I was appointed as the Vice Chair of the Commission in 2013, and then after Justice Mandisa Maya stood down as Chair because of her responsibilities in the SCA, I then was appointed by the President to chair the Commission, and that term ended last year in about July. I was then asked whether I'd make myself available for a second term, and I was reluctant because it's a fairly substantive amount of work that happens there. But I was prevailed upon, and they say in South Africa, when you're asked to do duty, then you put your hand up. And so I was appointed then for another 5-year term from late last year. And the work of the Commission is important and interesting, and I maybe will just touch on 2 projects that we currently at stage of finalization. The one is a project on prescription, and it's a very interesting project, and the report will be published soon, but it would deal with, for example, the circumstances under which a debtor may not, or a creditor, a debt that has prescribed may not be recovered, where you may not sue on a debt that has been prescribed, and where a court can mera motu take notice of prescription. The circumstances under which where debt that has prescribed already has been repaid, and whether you can recover that. But those are issues that I suppose the public will have an opportunity to comment on. The other project, which is an interesting one, is around family mediation. And the idea there is to recognize that we don't have enough mediation being used in our adversarial system. And the proposals there might be that in all cases involving family disputes, there should first be a recourse to mediation before litigation, unless a judge is satisfied that mediation would not have served any purpose. But coming to your question with regard to legal fees, Section 35 of the Legal Practice Act requires the Law Commission within 2 years of November last year to prepare and submit a report to the Minister that deals with a number of issues. And it includes the high cost of legal fees as being a barrier to access to justice, what measures can be taken to facilitate greater access to justice, whether there's a need for a tariff to be determined in respect of fees charged by legal professionals, and if so, what mechanism will determine that tariff, whether litigants will be entitled to opt out of that tariff, as it were, in terms of any voluntary arrangements. And we see that as an important investigation, because I think the reality is that legal fees are very high. I have a daughter who's an advocate, and I often argue with her at home, and I said, I love you dearly, but I don't think you're worth so many thousand rands per day. She says she thinks she is. But I think it puts the reach of justice beyond so many people. And sometimes we live with some of the absurd consequences where people who have absolutely large amounts of money can litigate on anything, whether the sea view is being blocked by a building in front of me. And on the other hand, there are people who can't even hope to reach a court. So that investigation is an important one. But we are mindful that it's going to be a contentious one, because there are people who want to protect their interests. Our hope is that the profession as a whole, the legal community as a whole, will recognize that unless there's meaningful access to justice and real affordability, that the law will fall into disrepute, that people will say, well, it's pointless having wonderful laws when we cannot access them and when we cannot afford them. And there's a limit to what Legal Aid South Africa can do. I think there's a lot that practitioners can do. I think there's a lot that the judiciary can do, and part of it is around the optimal use of judicial resources. I've been quite involved in case management, for example, at my court, and I found simply that effective case management works remarkably well in curtailing the issues for adjudication, narrowing them down to such an extent that ultimately when you go into court, you deal with what needs to be dealt with. Secondly, it contributes towards a resolution of the matter. And I think the greater use of mediation is one such initiative, I think. Community service, greater emphasis on pro bono work. But I think this is a joint responsibility, and we're starting work on that. We're starting the public consultation process, and we hopefully will report to you in a year and a half's time, Minister, with regard to our recommendations. What we are not required to do is to set the tariffs, but to make a determination whether it's desirable to do so, and if it is, what mechanism should be put in place to set them. Yeah. Yes. Thank you.
I guess whoever would be the minister at the time will look forward to receiving the report. Thank you, Chief Justice.
Thank you, Minister. Justice Kachalia.
Thank you, Chief Justice. Judge Kollapen, I've known you for many years, and certainly from the point of view of your sensitivity to the needs of the society, or the fact that you have an acute sensitivity to the constitutional needs of our society. I think all of that is really well established, and I think from that point of view, you, with respect, tick all the boxes. But I want to explore an area that I've explored with some of your colleagues who've gone before you, or who've been interviewed before you. And that is there's an area of private law, and I accept right up front that private law is not strictly private, because private law too, that the Constitution has a direct influence through various provisions on the private law. But there has been criticism in law journals and elsewhere regarding some of the judgments produced by the court in the private law area. And here I'm talking about commercial law, I'm talking about the law of delict. Are you aware of those criticisms?
I'm not, Justice Kachalia, maybe if, yeah.
Are you aware that there are debates going on, quite furious debates, in the law journals and elsewhere regarding some of the trends, some of the issues the concerns relating to judgments of the Constitutional Court? Are you not aware of those at all?
Not in the context.
And
yeah.
should you not be aware, given the fact that you are putting yourself forward to be a member of that court?
Perhaps I should, but I'm not, and maybe I don't read the law journals as often or as regularly as I should. At the same time, I would think that when one is, if one ever gets to sit there, no doubt those debates will play themselves out in any process that arrives there, and one will apply one's mind to that as well. So it may well be disadvantages that I'm not, but I'm not sure if that becomes fatal in a sense. But maybe your point is that if one is aspiring to sit in that court, you should at least have one's radar on in terms of what is happening and the debates around it, yes.
Yes, that's what I was trying to explore. So it doesn't sort of help to go into any of those questions in any detail. But one of the areas of criticism has been that there's insufficient skill in that court relating to commercial disputes. Now, I'm putting that to you as a genuine concern that is being raised. Whether the concerns are completely valid or not is a separate question, but I can tell you that there is a widespread concern. It doesn't help for anybody to put his or her head in the sand. That is a debate going on about that. So I'm interested to understand your skill in the area of commercial law. And how would you characterize that? Because I notice from the judgments that you have put forward that there are very few. There's a patent case. There are very few matters that deal with complicated commercial questions. Do you think that's a disadvantage for you or not?
Thank you, Justice Kachalia. I firstly, I'm not sure if the perception around there being insufficient skills at the level of the Constitutional Court is one that is sustainable in a sense, because in many respects, on the one hand, one could say that even in the absence of one's experience in a particular area of law, one brings to one's work certain core skills that you must apply in any case. So when I did my first patents case, I hadn't done a patents case before, either in practice or as a judge. And I think counsel was tempted when they introduced themselves to me to give me a textbook on patents. I'm quite sure they had it with them with the intention of giving it to me, almost to say, well, fortunately they didn't. And I wrote a judgment that was reportable, because I diligently then applied my mind to that area of the law, brought myself up to speed with that. And while the lack of experience may have been a disadvantage, it wasn't an insurmountable obstacle to producing what may well have been a good and a sustainable judgment. So I think in that respect, there will always be areas of law in respect of which one may not have been exposed to. But provided one takes the attitude that being a judge is an ongoing process of learning, and as long as you don't have the arrogance to say, I know it all, that I'm open to learning, I think that those difficulties can be overcome. And certainly, I've seen colleagues who haven't had practical experience in a particular area of law who acquit themselves well. I've had to deal with issues around royalties, issues around trusts, for example, which, as you know, when we were in practice, were not the kind of issues that would come across your desk. But as a judge, you must rise to the occasion and deal with it. Whether that's good enough for the test must be whether it is good enough for you to be able to write, to understand the issues and produce a good quality judgment. And perhaps by doing that, you actually deal with the perceptions out there. And sometimes those perceptions exist. But if you work with diligence, you actually can put to rest those kind of perceptions. And we know this happens. Sometimes litigants come to court and they agree to postpone a matter because there's a particular judge who's been allocated to hear the matter without anything further ado. And I don't think we also must allow ourselves to fall into that trap. I certainly think if a judge is regarded as appointable to the High Court or any other court, then the body that makes that determination must be satisfied, given the diversity of the law and given new areas of the law that haven't yet come to us. That person will have the core skills to rise to the occasion and do that.
If I could just then complete, do I understand you to say that in the area of commercial law, you may be deficient in your experience, but that is not, firstly, it should not preclude you from being appointed to the Constitutional Court, and second, that it is not an insurmountable problem. Is that your answer?
That would be my answer, but I would perhaps want to take issue with the term deficient, and I don't think you mean it in that sense.
Yes.
But my experience may not be as good as someone else's. But perhaps what one lacks there, if one can make up with integrity, diligence, and industry.
Yes, thank you.
Commissioner Nokesi?
Thank you, Chief Justice. Justice Kollapen, I think we will start where you left. There is a criticism that our judiciary has not done enough to promote and apply customary law. In fact, the African indigenous law, I'm tempted not to use even the word customary law, of which our constitution instruct for the application of that law. Would you agree with me that if candidates are not well prepared or have no good understanding of customary law, they, in their appointment, would need to qualify themselves in that area, so as they have to qualify themselves in relation to the so-called common law or Roman Dutch law?
I would agree with you that the idea of the development of customary law was certainly foreshadowed in the Constitution.
Yes.
That it hasn't happened is something that I think we all recognize. And in part, one of the problems I think that has been identified, and certainly Professor Tandabantu Nhlapo has written extensively on this, where he suggests that what is happening is the discourse around customary law in the Constitution is an unequal one. That whenever there's an expression of identity rooted in culture, then others immediately reach for the Constitution to silence you, because it's against. And I was involved in a case many years ago at the Human Rights Commission, and when I reflect on that, I think maybe we may have erred in our approach. And it involved the custom of mochacha. And there was a woman who lived in the Bakatla community, and she had married a man who lived, and the custom in the community was that upon the death of your husband, after the mourning period, and when you leave home, you would sprinkle herbs along the path so that there's protection to the crops and to the livestock. But she had, during the course of her marriage, become married to a Jehovah's Witness. And upon the death of her husband, she said, I will not do that particular custom. And there was a conflict. And the commission intervened, but we intervened on the side of the woman asserting her individual right, without recognizing perhaps that there's the right of the community as well, the right of association, disassociation, and maybe if she didn't want to comply with the custom, she should have opted out. But that's the challenge we face. But it's also, I suppose, how we function in courts. For example, the values. I mean, Ubuntu has come to mean anything and everything to everybody. But it hasn't been internalized. So to some extent, we must also take the responsibility for how we function as judges and how we allow the space for that culture to give expression, recognizing obviously that the Constitution says you have the right, but it's subject to it not being in conflict. But it doesn't create a secondary system, and that's the difficulty. So the whole discussion around ukutwala has been very interesting, for example, around what was regarded as the traditional form of ukutwala and then the aberrant form of ukutwala, and how the custom has become distorted over the years. And again, in the Jazila case, the court had to deal with it, yeah. But those are some of the, we've become quite westernized, I think.
Yes. Now, do you agree with me that commercial law, private law, private law, which form part of what we call the law, the common law, yes, common law. Those are cultures and practices that come out of the practices by Romans, the Dutch people come together, and later important to us as the African people. Is it fair to simply relegate the indigenous law insisting on these areas of specialization within the broader common law or Ramantash law? Is it fair to the majority of the South African? Is that fair?
I don't think the relegation is fair. I think there has to be a meaningful discussion around the development of customary law and its growth. But we need to be careful as well, because the point is made that sometimes there would be those who would seek to hold on to customary law simply to hold on to lost power. Whereas true customary law is about the reality of people's lives and how that can be given expression. So again, when we speak of customary law, we need to be careful about that particular nuance and understand customary law to also be a living system of law, a dynamic system of law. Yes.
Yeah, this is my last question then. Yeah, this is the last one. My last question is, would you agree with me that in South Africa, to be quite honest, our judiciary has an obligation to develop a South African law, which to me was brought about by the Constitution in 1994 and the process going forward, and to insist on candidates in 25 years to say, before you go to the apex court, constitutional court, let's look where is your amount of understanding of commercial law, particularly in view of the inequalities, the unfair practices, in particular with regard to the distribution of work, skilling of practitioners. Is it fair, really, to simply limit ourselves rather than promoting the Constitution as the supreme law of the Republic of South Africa?
Well, without suggesting how you should do your work, certainly you would want somebody who has as wide a possible understanding of the context within which law must make society a better place. And that has various components to it. And at any given time, some of those components may stand out stronger than the others. But I'm fortunate that at least that's not the decision I will have to make, but you will have to make.
Just in passing, have you realized that every discipline, even area of law, and universally, are taught with a particular objective in mind? You don't just teach economics anyhow. You don't just teach law anyhow. There is a setting that you want to create. There is an order, there is a system that you want to create with certain consequences. And a number of universities are very careful globally, and the foundations that fund them. You've got to fit within this system. You've got to channel people in this way of thinking. So even subsequent analysis flow from that. You veer off and say, nah, this doesn't quite address the economic needs of the people. Shouldn't we re-engineer the system? Then you're in for it. There's a particular end game. Have you realized that?
Well, Chief Justice, you raise a very controversial issue in a sense, the
Yes.
power of the law. And is law then about protecting the power of elites? And if it is about protecting the power of elites, then is the court limited? Because the court function within. So to give you an example, you have a case, an eviction case, and I had to write 2 review judgments not so long ago in terms of Esther. And so the farm worker faces eviction. And the farm owner has ticked off all the boxes that would, in terms of the law, justify an order of eviction. But the historical landlessness of the farm worker is not featured into the process.
But
So-
if you are shallow as a judge, you just look at the law, you listen to argument, you say, oh, you are shallow, there's no constitutional vision within which you operate in that guides you. So, okay, the boxes have been ticked and that's it. And isn't that the problem, really? Isn't that the trap into which we fall most of the time? And I raise this with you because it's the constitutional court vacancy we're talking about here.
Well, that is the problem, but then it must beg the question, how can somebody who has lived in this society, who is 40 years old plus, not have that consciousness? Then where were you all your life?
But where do you get it? I mean, you were not taught that way at university level. It's another program altogether. What do they produce? And you move from there, you get a scholarship. Which scholarship is it? Why was it started? What are the objectives behind that scholarship? It's free, granted, but there is free and there is free. What orientation comes with it?
Sure.
Those are the fundamentals that we never touch.
No, I'm mindful of those issues, but it still doesn't detract from individual responsibility. I'm the agent of my life, and it would be a sad day if I had to attribute the bad things I do to being influenced. As an intelligent person, I must take responsibility.
Yeah. And there must be progress. Commissioner Nyambi?
Thank you, CJ. Afternoon, Judge.
Afternoon, Commissioner Nyambi.
Let me take you back to 1995 when the late former President Tata Madiba appointed you to serve in the committee that was responsible for selecting those that were to serve in the TRC. How did your participation in the choice of candidates shape the outcome of the work of the commission?
We had an unenviable task of having to select people to sit in a structure that we as South Africans didn't know how it was going to unfold. So it wasn't as if you were appointing a judge or a cabinet minister. It was a new animal that was created called the Truth and Reconciliation Commission that had to help us deal with our past, unpack it, deal with the difficult issue of amnesty, and provide a kind of chart to the future. So we were also mindful that the commission had to be representative of South Africa. That given what has been described as the deep suspicion that existed between South Africans then, it had to be a structure that would engender, as it were, that kind of confidence. And so we went around the country after having opened up the process for nominations and interviewed people to get a sense of their own commitment and their understanding of the historical injustice, the need for reconciliation, and really use that as the basis. I remember us trying to interview Archbishop Tutu. It was very difficult because I think he ended up interviewing us. But we had the opportunity to ask him some questions. And then we finally actually went to the president with the list. And we pointed out to President Mandela at the time that we didn't think that the list was representative because we were bound by people who were nominated. We couldn't go outside that process. And we said there's certain constituencies that don't feature in our list, but we think you need to give consideration to appointing people from those constituencies, which to his credit he did, and that's how the TRC came into existence. And up to today, there are debates about its work, and certainly it took us forward. But there might be arguments that there was the need for that kind of work to continue, because people saw it as a once and for all, and it's done, and you move on. Whereas the truth and reality is that we're still dealing with the problems of the past, and we still battle with them, yeah.
My last question linked to the one that has been asked by CJ and the one that I've asked you now. What's your personal view about our own arrangement when it comes to selection of judges?
Well, apart from the fact that I haven't had much sleep this week, I think it's a daunting process, but I think understandably so as well. You put yourself up for appointment to a high court or to the constitutional court, then you must be willing to expose who you are, socially, politically, emotionally, jurisprudentially, in terms of your skills, because ultimately we live in a society that is committed to great transparency. So, and the nature of the questions are varied as well. You know, they a mixture of the political, and then law is political in many respects. There's the legal questions, and so I think it's a rigorous process. Sometimes it may be uncomfortable, but I certainly don't think it's unfair. And sometimes a bit of discomfort may not be too bad as well.
Thank you, Judge, once again. And I checked the previous question. Commissioner Malema encouraged you that even if you are not appointed, you must come back, and you are back. Thank you for that.
I hope
Thank
you're
you, CJ.
I hope you're not going to encourage me to come back again.
Maybe it's his turn to encourage you. Commissioner Singh?
Thank you, Chief Justice. Good afternoon, Judge Kollapen. I just want to follow up on the question raised by the Minister, where I think he needed to ask you this. The commission that you are heading to look into access to justice and high fees, because it's been the subject of discussion in the last few days. I know you wouldn't have drawn up the terms of reference and the timeframes, but I'm a bit concerned that you mentioned 1.5 years to complete the work, because seated right here in this very room, I think are the people who are direct or representatives of the profession that are directly or that will be directly affected by any recommendation you make. And I trust that they would take up this matter before getting any correspondence from yourselves to respond and to make submissions. And I'm looking to Commissioner Fourie, who's looking at me, and the Commissioner from the bar. But what are you finding so far in that regard? Because you're quite right, and we accept that access to justice is just, prohibitively expensive.
Well, Commissioner Singh, the processes of the Law Commission is such that what we did is immediately after the coming into operation of the Act in November, we convened a conference with all role players, including the profession, paralegals, communities who use services, just to highlight the issues. We've now produced what is called an issue paper, and the issue paper is the basis of the public consultation, and that is going out as soon as it's edited, it's complete. But we're also mindful that we can't send out a document and put it on the website and expect those who are most affected by legal services, the lack of legal service, to meaningfully respond to it. So we're planning a public consultation process as well, where we will go around to all the provinces, working with the paralegal structures to get ordinary people's experience, because what has emerged is that you don't always need legal services to solve a problem that may be characterized as legal. You don't always need a lawyer. Sometimes a paralegal would do. The university law clinics have come up with a strong proposal that university law students should be allowed some limited appearance rights under supervision of their principals. The idea of community service. So there's a growing trend on one side to say not everything that is legal in nature needs a fully fledged lawyer. You can use skills of a lesser nature depending without compromising. Then what has also emerged is that the sort of major law firms have said, hold on, if we have a client who comes in and says, we want to be involved, we want you to do a piece of work for us, and price is not the option, then should you, as the Law Commission, be interfering in that? That's a private matter, it's not affecting them. The counter argument is, well, if you're going to pay 5 million, what effect is it going to have on other factors? And then the third area may well be the initiatives of the profession itself, how one can begin to consolidate them. But it is a serious problem. I mean, you sit in the High Court and people are losing homes and they don't have legal representation. Now, you can't have a Rolls-Royce constitution when someone is not able to meaningfully use it. So I think it's going to be quite a contested process as well. And one hopes that perhaps people see the bigger picture.
We live in hope. The Chief Justice did mention a case yesterday, I think R1 million for an opinion, and somebody was prepared to pay, Chief Justice, R1 million.
Well, I don't know if they were prepared to pay. I know an advocate charged.
Advocate charged R1 million. My second question is, Judge, is that you've been involved in the Human Rights Commission for a long time now. Now, 25 years into democracy, one would think that we can become a maturing democracy in terms of race relations. Now, social cohesion seems to be evading us more and more. We seem to be getting further apart because of certain things that happen within society. What can be done with your experience? What's going wrong?
Well, I don't think you can divorce sort of race relationships from the lived reality of people as well, because equality is very much a part of feeling included in a society. So if your life is one of exclusion, then there may be a risk that you would look towards others who have been included and whose lives are much better than yours. And sometimes race may play itself out there. Sometimes race is used gratuitously as well, when the issue is not a racial one, but it's easy to ascribe it to race. And sometimes, as former President Mandela said, is that we slaughter each other every day with the words that we use. And I know there's a debate around hate speech, but often the benchmark for hate speech is very high. It must constitute its incitement to cause harm. But sometimes you can damage somebody in such a way that it may not constitute hate speech, but it's deeply damaging. And so I agree with you on the one hand that there isn't a maturity within the society. But I also think that we only deal with issues around race and exclusion when there's a crisis, when someone has done something wrong. We don't have an anti-racism program in this country. FIFA have an anti-racism program in football. I mean, a football association has that. A country that has a deep history of racism doesn't have an I'm not aware of any national anti-racism program. I know when South Africa submitted its report to the United Nations many years ago, and I was in Geneva, they submitted 2 reports at the time. The one was on the Convention for the Elimination of Racial Discrimination, and the other one was on the Convention Against Torture. There were 3 South African NGOs who prepared shadow reports on the Torture Convention. There wasn't a single South African NGO who prepared a report on racism. If you were not South African and you were in Geneva, you would have thought that torture is a bigger problem than racism. So it's again how we've identified it. I think it's a deep shame that we don't have an anti-racism program in this country, because when you talk about racism after a particular incident, it's not the right time. There's polarization. People immediately move into their groups, and the ability for meaningful dialogue goes.
Thank you, Chief Justice.
Thank you so much, Honorable Singh. Commissioner Smith.
Thank you, Chief Justice. It feels like I'm treading on holy ground here, but I would like to refer you to your minority.
I'm a Hindu, so there's no sacred cows.
I did not refer. But could I refer you to your minority judgment in the Helen Suzman Foundation matter? And I don't want to discuss in detail, but you did refer to, if I could read it out, to the fact that it may have an impact, relevance for the judiciary's independence, integrity, efficiency, and in particular the caliber of those who constitute it. And part of it is the notion out there that suitable candidates do not make themselves available, and I'm not referring to you at all. But there seems to be a train of thought, at least, that it's one thing appearing before the Commission and asking questions over which you have no control, but at least you're in control of the answer and countering whatever question is posed to you. But there seems to be another view, or not another view, but a view as well concerning the deliberations of the JSC, which was normally held behind closed doors. Now, it was found to be relevant. If it's relevant, then it must be made public to a court of law. And I think you found that in the light of considering the interests of candidates, members of the JSC, and the JSC as an institution, it should not be made available. Now, I'm not so much worried about the members of the JSC. Some of us are more vain than others, but that we're in control of that particular allegation which may come our way. And the JSC, of course, is an institution, is up to the members of the Constitution. I'm more concerned about the interests of the candidates, because sometimes we make comments that may be seen or may be perceived, well intended or not, to be harmful, hurtful, ill-considered, disparaging, whatever adjective you can add to it. But more, I think the judgment has been delivered, and it is, you can't turn around. But my question is, which kind of interest of candidates, what kind of, if you refer to the interest of candidates, what kind of interest we're referring to? Because it is the interest particular of not only the applicant, but also other candidates who are not part of an application for a review of the decision of the JSC. That is more concerning to me than the applicant saying, well, if you want to apply for a review, you've got to take what's coming your way. Yeah. But it's the candidates who are not part of the application, whose interests, I think, are tantamount to the exercise of what I think you may have referred to. Would you like expounding on it?
Well, I think I refer to the candidates who come before the JSC as well. In a sense that when you sit here, you come here and you have to accept that you could be challenged on anything, and you have the opportunity to respond. I'm not sure how your deliberations work, but I imagine when you deliberate, somebody who may not have asked me a question may say, I think his judgment's writing skills are atrocious, okay? And and someone else might say, well, I disagree with you, but that becomes part of a sealable public record in the event of a review. Someone could say, well, I think his moral and ethical leanings are questionable, right? In the deliberations, I'm not sure, you don't have to justify it. It might be an instinctive view. You may, during those deliberations, be convinced as the discussion goes on that initial view is wrong. But you may not be obliged to put it on record. You may vote in a particular way, and I don't know if you're voting in secret. But post the interview, that becomes part of a record in the public domain if there's a review. And there's absolutely nothing that I can do to change that. If someone said, well, an eminent member of the JSC found that your moral leanings are questionable, well, all I can say is that, well, I've never had the opportunity to deal with it, but it's there. And once it's there, it's there. So that was my concern. I'm mindful that the Chief Justice normally would prepare a summary of the deliberations for the purposes of a Rule 53 application if one is brought. But my concern was that process. And certainly in PAIA, the deliberations in employment processes are also protected and not the subject of automatic disclosure. So there is some justification for at least protecting that. And other candidates would have a sense as well of the reasons, not from the transcript, but from the reasons prepared by the Chief Justice.
If I may just follow up, my concern is not so, well, it of course is a concern that someone, a member of the JSC, may make a disparaging, unfounded disparaging in certain instances, or may be founded, for the moment, theoretically. But I'm also concerned about those individuals or candidates who appear before the JSC whose possible disparaging remarks comes to the fore in terms of the transcript and has nothing to do with the application, who has not taken the risk, whose moral ethicalness or otherwise, or ability to write judgments is not possibly unfounded, but he's not party to the proceedings, and it's out there in the media everywhere without having an opportunity of a reply. So it's more, my concern is about those who are not involved in the application, whose, when the transcript is made available, it is open to the whole public. So are there ways of countering that kind of damage?
Are you referring to those who are not recommended? But when you say not involved, I'm not sure, because the transcript would be in respect of candidates who came before the JSC only, not so.
Those who are appeared before the JSC, who are not recommended, and who may have been disparaging comments have been made.
Sure.
Anyone, any one of those candidates.
Yeah. So it can be potentially damaging. Yes. And I'm not making out a special case for protecting people. I'm saying that the opportunity to deal with that which is negative is here. The deliberations take on a whole different framework. And as I said, I don't know what happens there, but I imagine there's discussion, there's instinctive views that are expressed, there's persuasion, people change their positions, but that may not all be part of that record. And that record then goes out in that fashion and can be potentially quite damaging. So human dignity is at the heart of this constitution as well, and that's not a special case, but it happens in a space where I, as a candidate, don't have any opportunity to impact on that.
Thank you, Honorable Schmidt. Commissioner Furry.
Thank you, Chief Justice. Good afternoon, Judge Kollapen.
Good afternoon, Commissioner Furi.
I didn't mean to really ask you something until Commissioner Singh pointed me out. But on the issue of your investigation, the Law Reform Commission on costs, which I'm sure we'll gladly, as a profession, engage and participate. I understood you to say that your mandate is not to actually determine the actual amounts, but to create a framework or a proposal as to the basis how it should be calculated or how it should be done. Am I correct?
The mechanism that should do it.
Yes.
Yes.
And that's the only aspect that I would like to engage you on and seek your comments. The legal profession, by and large, sells time and charge on a time-based system, if I may call it that. Apart from the fact that I think hourly tariffs and day fees are in some instances exorbitant, the problem of selling time and charging by the hour is also a real problem, because it tends to reward inefficiency. For example, the slower you work, the more hours you clock. The less of an expert you are in a certain field, the longer it will take you to get to an answer and provide an opinion, as opposed to a real expert which might be able to do so within minutes or an hour. The other problem is, when do you charge? Do you charge when you lie awake at night thinking about the problem in your bed? Do you charge when you stand under the shower and thinking about the matter? Do you charge when you drive in your car thinking about the matter? Or are you only entitled to charge when you sit behind your desk in your office? So there's a big problem there, and I think the tendency is to try, if possible, move away from time-based accounts, and I think that, by and large, would be what the public demands. Are those the type of interrogations and discussions that you envisaged the Commission will have?
I think, Commissioner Furi, in part, yes, it's the genesis of how the fee then is constructed and what is the basis. For example, should it be based on the value of the work to the client? Should the client's ability to pay be a factor? One hopes that it can be as nuanced as that, and I'm not sure if we're going to get there. But clearly, time-based accounts may well be a problem, because I've had a discussion with a lawyer the other day who said, well, look, we estimated the time here to be 5 hours, but we think this is worth 10 hours of time to the client, so we're going to charge for 10 hours.
Yeah, that can't be, but
No,
be that
that
as
can't
it may.
be, yeah, yeah.
No, thank you. I just wanted to
Thank you.
test that with you. Thank you, Chief Justice.
Thank you very much, Commissioner Furry. You know, a thought just struck me, Judge Kollapen, and it is this. Discrimination on the basis of age is not permissible. But I was just wondering, You are heading for 62 now. And in terms of section 176 of the, is it the Judges Remunerations Act? No, the Constitution, I'm sorry. 76(1). It says a constitutional court judge holds office for a non-renewable term of 12 years, or until he or she attains the age of 70, whichever occurs first, except where an act of parliament extends the term of office of a constitutional court judge. You know the latter part we had a problem with. Now, if appointed, it means you will be there for a period less than 12 years. You'll be with you'll be with a court for 8 years instead of 12. Should that be factored into our reflections in relation to who to recommend for appointment in circumstances where another candidate who may have performed a little less than you did, who did not score, say, who doesn't, after deliberation, score highly as maybe you have, but is able to serve the Constitutional Court for a full 12 years. Is it appropriate? Is it fair? Is it just to say, wait a minute, the nation deserves more? It's not right to have somebody serve for 8 years and then he retires and earn the full Constitutional Court justice salary in retirement, when we have an option to have somebody relatively younger who can serve the full 12 years and only cause the state to pay for the same position after additional 4 years as compared to Judge Kollapen. Any comment?
Chief Justice, I think that it's a factor that you can't ignore, and certainly it's something that I'm sure may occupy your deliberations. Having said that, I think if that factor was dispositive of the issue, that would be unfair. If that factor determined the issue on its own, you would have to look at that together with a number of factors. And the other factors would be looking at me as a candidate, leaving aside for a moment the fact that I will be 62 next month. I may say that if I have to serve for 8 years, and I say this with the greatest of respect and humility, the country may well get 12 years out of me in terms of what I bring to bear to my work. And I say this in all seriousness. I also say that from 1996, I served my country from being appointed as a commissioner to the Human Rights Commission. And that's been continuous and ongoing service as well. Maybe not to the judiciary, but to the cause of justice in this country. And I do hope that that would also be a factor that goes into the weighing up exercise.
No. When I said a candidate who scores a little lower than you did, let us assume that we are allocating marks. That's what I had in mind. You score 85, he or she scores 75. And then, all things considered, we also take this into account. We say, well, the other person will also serve very well. The other person also has an impressive track record. But Justice Kollapen is stronger than this candidate. The other person is very diligent too. It was in that context that I raised the issue.
No, I accept that that may be a factor. I only express the hope that it's not dispositive, and perhaps that the clock doesn't start, as it were, in 2010, when I started acting. As I point out, my clock started in 1996 in the course of justice, to the extent that I think it may well be a factor. How you weigh it is something that you would have to
Sure,
consider.
sure. No, I'm sure it's a factor. That's why so much time was devoted to conversing that issue with you. It's not any relevancy. It's something that, generally speaking, I think it needs to be taken into account, and I hope it will. Thank you very much, Judge Kollapen, for coming again.
Thank you for the invitation and for the questions that you put to me, which I hope I have responded to. Not sure to your satisfaction, but at least responded to. Thank you.
No, thank you very much. You're excused.